everyone, and welcome to this week's episode of our live webinar series, proudly presented by immigrationquestion.com, your trusted destination for immigration updates, legal insights, and real time conversations with licensed immigration attorneys. My name is Anisya Mukherjee, and I'll be your host for today's session, H2 Visas Compliance Essentials for 2025. Hiring temporary workers through the H2 visa program, whether under H2A for agricultural jobs or H2B for non agricultural jobs, can be a lifeline for many U.S. employers. But here's the catch: it comes with strict legal responsibilities. In 2025, regulatory oversight is only increasing, and the risk of for getting it wrong, whether intentionally or not, can be costly. That's why we are here today. This session is designed to give employers, HR professionals, and immigration advisors the clarity and tools they need to stay compliant with today's evolving H2 visa rules. And to guide us through it all, we're honored to be joined again by attorney Meagan Kirchner, founder and principal attorney at Kirchner Law with nearly a decade of experience working with H2, H1B, and TN visa cases. Attorney Kirchner brings the legal know how and practical insight employers need to make smart, compliant decisions. Welcome back to the show, Attorney Kirchner. Thank you so much for joining us today.
Thanks for having me back. Happy to be here.
Before we get started, just a quick reminder, immigrationquestion.com is a two-in-one platform that connects users to licensed immigration attorneys. We are not a law firm and we're not affiliated with ILA or USCIS. All legal services are provided independently by attorneys registered to our network. Now, Attorney Kirchner, let's start with the basics. Can you explain the difference between the H2A and the H2B visa programs and what type of workers or industries they typically cover?
Sure. So the H2A visa is, as you said, the agricultural side of that seasonal visa type. So those are tasks that like planting, harvesting, livestock care, operating farm equipment, those kinds of jobs that happen on agricultural workplaces like farms. These are usually seasonal and tied to either a growing season or some sort of agricultural calendar. Now, H2B, on the other hand, kind of encompasses pretty much all the other kinds of temporary seasonal jobs or a one-time need kind of job like a caretaker or a nanny that's a limited circumstance, limited time. Think construction, landscaping, hospitality, seafood processing, or amusement parks, carnivals, those kinds of jobs that are kind of cyclical in nature. Now, these roles can be, like I said, either seasonal, meaning that this kind of job only happens during a certain time of the year and this employer doesn't employ people in the rest of the year, or peak load, meaning they operate year round, but there's a certain discernible increase in busyness or a demand during a particular time of year. A quick way to remember it is A for agricultural and basically B for everything else. It's a kind of a simplistic way to put it.
Definitely. All right, interesting. Now, compliance is a huge concern, especially in 2025. What are some of the most important compliance obligations for the H2 visa employers this year? And what are the risks if they fall short?
So, right now, across all visa types, I-9s are tremendously important. Those are increasingly the subject of audits specific to I-9. So that's making sure the workers have the proper documentation and work authorization to be employed with a U.S. company. And I find that a lot of employers will forget that step or maybe fill it out incorrectly. So it's very important to make sure you're following the proper procedures for that. There's lots of great guides online, available to show you how to do those forms step by step. And like I said, that's really across every visa type, as well as your domestic employees. It's not limited just to immigration. So that's something, workforce compliance overall. I would encourage all employers to take a good hard look at and maybe just start a self-audit to make sure you're in compliance with that. H2B specifically, you're really going to want to be looking at your prevailing wages, all of the terms and conditions of your work contract, making sure you're in line with those terms. As part of the requirements for H2B, another thing to make sure you're doing It's that these employers are looking at their corresponding U.S. employees. If you've got a corresponding worker, they can't be treated in a way that's different or inferior to you can't prefer a foreign worker or offer a benefit or pay to a foreign worker that you don't also offer to the corresponding U.S. worker. That's a big point that you're going to need to keep an eye on. Working conditions are very important. So making sure that they're, in compliance with their OSHA, with, whatever other safety procedures that they need to be in, from a state level or federal level, whatever workforce safety. Now, again, specific to the H-2B, work contract compliance as far as job duties and location are also going to be very, very important, because if there's a site visit from either USCIS or Wage and Hour or anybody else, they're going to ask both you and your workers, what have you been doing? What kind of job duties have you been doing? Where have you been working? And if you've had the workers working places that they are not already approved on their H-2B paperwork, or they're working duties that go above and beyond the occupation that you have been certified for, you're going to run into problems, because there's a particular wage requirement for H-2B, and that wage is based on the type of position and where it's located. So if you're deviating from that, you may be in a situation where you're not paying the worker enough. You're certified for a landscaper making $19 an hour, but you're having them do heavy construction that should be paid $26 an hour. So you're going to have back wage issues and penalties that you don't want to have to deal with. So all of these things are important things to look out for. They're, of course, not limited to that. There's many things that you're going to have to look out for, but those are the big ones. And those come at heavy cost. Back wages can have wage penalties, as well as the wages due to the workers, U.S. and domestic and foreign. So this is going to apply both ways. There's also very, very steep fines for I-9 violations. So I cannot emphasize enough how important it is to be familiar with your H-2 contract, make sure you're adhering to it, and also just more broadly, making sure you're in compliance with your I-9 requirements. Another thing that's kind of ebbing and flowing and comes up periodically for certain employers is making sure you're staying abreast of the state-specific requirements for your workforce. And this is not limited to H-2B, but your H-2B workers are also full-time employees, so they likely qualify for some of these benefits. Like a lot of states are enacting, minimum sick leave requirements, things like that. So just all things to be aware of, and make sure your managers, HR, everybody is following all of those rules.
Thank you. So let's look at it from the worker side, actually.
Sure.
For H-2 workers already in the U.S., what steps must they take to maintain their legal status and avoid violations?
So from the worker's perspective, when they arrive, or before they arrive, actually, they'll get a copy of the work contract. That, again, will detail who they're working for, where they're going to be working, the type of duties they're going to be working or performing, the pay rate, any deductions that could be authorized or applicable for the position. That's going to be the document that's going to have all the really important information they need to know. And from their perspective, for their own benefit, they need to make sure that that's not deviating from those things, because they don't want to be exploited or taken advantage of. So good to know their rights, as well as, every workplace will have a poster up which lists H-2B rights, all of those kinds of wage and hour whistleblower protections, things like that. Now, I get this question a lot. It's, can we work somewhere else on the weekend? And the answer is no. Your responsibility is to work for the employer that's listed on your visa, or your USCIS I-797, because maybe you'd already done a change of employer. So whatever your current status document is, or work authorization, you are only authorized to work for that employer. So, you're making sure you're following those rules and working for only the employer that you've been authorized to work for. Because if you don't, that can be a good way to jeopardize any future visa chances. Also, it's very important to work with your employer. If you want to take leave or have a vacation, or if you're sick, just keep them informed, because what you don't want to do is disappear for 5 days. Maybe you had a family emergency, maybe you're really sick, but you didn't tell your employer. If you're able to tell your employer, you should do so, because your employer has the obligation to report missing employees. If you've been missing for 5 days or more, it's basically an abscondment, and they have a duty to report that to Department of Labor and USCIS. And what you don't want to happen is have your employer not know what's going on and then report you as an early departure, but really you had every intention of coming back. And if you had just communicated with your employer, you could have had voluntary leave, and they would have, just noted that you were absent, approved absence. So that's something that you can do to help yourself. I know in some circumstances there may be an emergency where you have to leave suddenly, but it's good to keep your employer informed of that. Another important thing to note is when your visa starts and when it ends. With the H-2B, you may be allowed to come in 10 days before the start date. For instance, your start date's April 1st. You're allowed to come in 10 days before that, oftentimes, if you've already got your visa. That time is meant to give you time to go to the grocery store, get acclimated in your apartment, kind of get the lay of the land. It's not meant for you to start working. Like, say you get here March 25th, you're not able to start working that day. You can't actually start working until April 1st. The same thing will apply at the end of the season, so be aware of your authorized work dates. If your season ends on November 15th, as of January this year, you have 30 days of grace period you should have been allocated on your I-94. So you have that 30 days through December 15th that you have an authorized stay in the U.S., but it's not work authorization. So you can't work past November 15th, for instance. So those are all important things to keep an eye on as from an employee's perspective.
Thank you for that insight. Another question we got was, job changes are a common concern. How can H2 visa holders switch employers legally? And if so, what's the process? What do employers and workers need to watch out for?
Sure. So there's a couple of ways for that to happen. If a worker has already been admitted to the U.S., they've got a valid H-2B visa or a valid extension, they can switch to another employer. That new employer has to have a valid Department of Labor temporary labor certification. So they need to be approved to file for H-2B workers. And if they are certified and approved, the new employer can file an I-129 petition to spot for a non-immigrant visa status, to change employer for that worker, to change from company A to company B. Under we'll get into this again with some policy shifts, but in January, they made what's called portability permanent, which means as long as that worker's new employer filed the change of employer application with USCIS before their current status expired, they are able to transfer to that new employer, even though the case is still pending with USCIS. So they get 60 days to work for the new employer while they're waiting for that to be approved. So that allows them less, uncertainty in that transition period. So, and it gives them the ability to, not be stuck at the prior employer, or maybe their prior, they filed it timely, but their prior employment has lapsed. So that prevents some of that, kind of lack of employment or middle areas for a lot of employees and employers for that matter. So that's one way, is you have to have a new employer that files a valid petition with USCIS. And that will be an in-country transfer. In that case, again, you're going to go from U.S. employer to U.S. employer. The other option, just depending on how the new employer has filed, it may be that you're quitting the other job early, like your current existing job early. So you want to, you have to go to your home country and go to the consulate to get a new visa for the new company. So if say your new employer has already been approved, but they filed for out of country visas, they were unnamed visas, you will have to go to a consulate to get a new visa with the new employer and then come back. One important point for that is if travel is always covered by employers, right? So in the case of a transfer, your new employer would pay for the travel costs between whatever city. If you're coast to coast, it might be a flight. If it's local or not too far to drive, maybe that's a bus. It's going to be least cost carrier that they're responsible for. So if they offer you a bus ticket, you can either allow them to buy you a bus ticket, or you can choose to fly and they'll pay you what it would have cost for a bus ticket. You're on the hook for the difference, but they are responsible for at least that low cost carrier travel for you. In the case where maybe you're transferring, or maybe your current season is ended and you want to, and it's that old employer, as long as it's ended, if you've done the full contract period, they're responsible for paying your travel to your home country. And then when you're there, your new employer will then pay your travel back to the US on that new visa.
Thank you. So this was something we were discussing before as well. So there's been some new movement on worker protections recently.
Sure.
Are there any 2025 regulatory changes or updates that H2 employees or workers should know about?
Yeah, so a couple of things have happened for H2 employers. For H2A specifically, there was a final rule in 2024 that had expanded whistleblowing protections and anti-retaliation protections for workers. There were also increased safety requirements and clarified job order obligations for the employers. Now, it's been a little bit of a roller coaster with that one over the past couple of years. There's been a lot of court cases floating around. So at many points, there were certain parts of it that were applicable in certain states, but not others. And because of all of the chaos involved around that rule, on June 20th, the Department of Labor's Wage and Hour noted that they were suspending enforcement of the certain provisions of that rule. And then again, on July 2nd, there was a DOL published a notice of proposed rulemaking to rescind the entirety, or many provisions, the rule entirely. But there's a public comment period open through September, so the jury's still out on that one. But there was also an H2 modernization rule passed in January, which is still in force. And what that one did for H2B in particular, there are certain categories of mandatory denials for employers. So if there's been certain issues with an employer, they're not going to be able to file for H2B anymore. So it's really encouraging compliance for employers. So that may be H2 program debarment, fraud, or engaging in unauthorized employment. So hiring people that don't have work authorization. Those are issues. There's also a whole host of items for employers that there's discretionary ability for USCIS to deny the petitions based on a certain, other grounds. So, those are certain things that are important for employers to look out for, because it will impact the viability of their future filings. In addition, as I mentioned, there's H2 portability. So for H2B, now if there's a timely filed petition, they get a 30-day grace period to find a new employer or switch employers. So that's something that should make it a little more fluid for transfers or these change of employers we talked about. Before it was 10 days, and there just wasn't enough time to do that, especially with the long DOL processing times in the spring. So if someone was transferring from a winter visa to a spring visa, there were many times where your winter visa was going to expire before your spring visa, even though your employer you're intending to transfer to will ultimately be certified. It's just because of processing times, it will be later than they would have liked. So this gives a little bit more flexibility there. There was also the elimination of the H2B eligible country list, which opened up H2Bs to many countries that I've had inquiries on in the past that were not on that list. Now, that being said, in practice, we haven't really been able to experience how those consulates, like India, for instance, are going to process H2Bs. Are they going to be difficult? Are they going to understand the program? Are we going to have denials or administrative processing that we're not going to, we're going to have to learn how to navigate? Those answers are still unclear, because it's so early that, many employers haven't tried to process workers from some of those other countries, but it is technically open now. Now let's see. We talked about the grace periods. Oh, another important factor that is nice as part of that program or process rule is It used to be for H2 that you needed to, every 3 years, you would have to reset your H time essentially. So you have to be out of the US for 3 months in order to be eligible to re enter on an H2. Now they just reduced that and simplified it to 60 days, which makes it a lot easier between seasons to reset that clock. So those are really the big points. There's a few other things, components of that modernization rule that, we won't cover here right now, but there's a lot of movement. And right now we're kind of on pins and needles to see if they're rescinding the H2A rule. Are they going to take a hard look at the H2 modernization rule? We just don't know yet. And there's, positive things in the H2 modernization rule for, protecting workers, keeping employers compliant, and making sure that there's penalties for non-compliance that are, to protect the program integrity, as well as the portability, grace periods, and country lists, elements that are really beneficial to both employers and workers. So we'll see what happens with that.
Definitely. To our amazing audience, thank you for joining us. Whether you're tuning in from Facebook, YouTube, or LinkedIn, we're thrilled to have you here. We are immigrationquestion.com, a two-in-one platform built with lead and case management features to help simplify the immigration process. Though we are not affiliated with AILA, we are trusted by a lot of AILA attorneys who use our platform. You can ask your immigration questions for free in any language and get connected to a licensed attorney for guidance. You may also receive a free confidential initial consultation. Just visit www.immigrationquestion.com and sign up today. And in some exciting news, we've just launched our new app built to serve both attorneys and users seamlessly. Attorney Kirchner, as an experienced immigration attorney, what do you think about immigrationquestion.com and what it's doing for the immigrant community and even for immigration attorneys like yourself?
So the newsletters and push notifications for these news updates are extremely valuable, especially in this environment, because there's so many changes happening so rapidly, and it feels like every program is so fluid at this point. When today something is enforced, and maybe tomorrow there's a court case and it's not. So, staying abreast of what's happening is important from both the attorney's perspective as well as clients, HR. Everybody needs to kind of stay in the loop. So it's certainly a great tool for everyone to keep involved and informed in this volatile landscape. And the app itself is extremely nice and easy to use. So, I don't have the user experience from the client side, but I can say that, if they try it, they're going to be happy with it.
Thank you so much. Thank you, Attorney Kitchener. We're happy to hear that. So before we dive into our live Q&A session, we just had one question. What rights do H2 workers have if they experience wages theft, unsafe conditions, or retaliation? And how can they seek help without risking their immigration status? I know you spoke about this a little bit in the beginning as well.
Right. So there's a couple of mechanisms with Department of Labor and OSHA that they can reach out to for conditions and violations. It can be intimidating for them. So there's also many states or regions have farm worker protection nonprofits or things like that can kind of help them also with that process and figure out the right contact to ensure that their rights are going to be protected, but also make sure they take the right steps to get the right people into contact with the right people or agencies to help them. Additionally, they may qualify for, other immigration forms of relief. So they could contact humanitarian immigration attorney to see if they qualify for a U or a T visa, if they've been a victim of a crime like wage theft or trafficking. So there are, various agencies, nonprofits, and attorneys that can help advise them in a situation like that where, they're feeling frightened or uncertain.
Okay. If you're joining in, we've been having a very insightful session with Attorney Kitchener on the topic H2 Visas Compliance Essentials for 2025. We're just getting into our live Q&A session, and this is your chance to ask Attorney Kitchener your own questions directly. Just type them in the chat or call us live at 516-703-3483. My EAD C9 concurrently estimated online account time says 3 months, and now it's 5 months, still no decision. Can I do an inquiry now or wait until the 6 months when it's officially outside of the process time?
So there's not going to be a set or anything that prevents you from submitting the request early. However, most likely if you're not quite moved outside of processing time for the wherever the processing location or service center that you've been assigned to, you'll likely get a canned stock response that says your case is within processing time. We'll let you know when we need something else or when any status changes. So it won't necessarily hurt anything, but it's probably not going to help either.
Thank you. Next question is, okay, I paid $1,500 to a recruiter in my country for my H-2B job, and now I hear that's illegal. Can I get deported even if I didn't know?
It likely won't impact you as the worker for getting deported. However, your employer under the current rules needs to be made aware of that because they're on the hook for making sure the recruiter that they're using doesn't charge workers fees, because that is correct. As the worker, you shouldn't pay for any part of this process. The employer pays for transportation, processing fees, if there's any recruitment fees or anything like that. The employer is responsible for those parts of the process. And if you're working with a reputable recruiter, they sign an attestation that confirms they're not, being charged anything for any part of that process, or they're not going to charge for any part of that process, and they're monitoring their employees to make sure they're also not paying for any part of that process. And this is an important point, just to, in fact, on my employer's work contracts, there's a section that says for the worker in their language that says, I'm confirming that I haven't paid for any part of this process. So we make sure we ask them as many times as possible to make sure they haven't paid these unlawful fees, because it's wrong for the worker to pay them, but it's also a liability for the employer, because they are, whether they know about it or not, the government will find them on the hook for that. So it's important information for your employer, because we don't want that to come up later and harm either of you in that case. So, and this could happen at any stage in the process. I've heard it happening with recruiters. I've heard it happening with people arranging travel. I've heard it happening with staff in the U.S. that maybe referred someone. Maybe it's a family member. Maybe they're from the same village. Whatever form it takes, it's not something that's allowed, and the workers should definitely raise a red flag for anything like that's happening, so the employer can either remedy it and also make sure they don't use that recruiter next time.
Thank you. Next question is, my job ended unexpectedly, but someone said I have 60 days to stay in the US. Can I work during this time or must I leave?
If you're H-2B, you will have 30 days of grace period to find a new employer. During that time, you can't work unless you are working for the employer that's on your visa. If during that time you find a new employer and they file an application, you're still in your grace period. Under that portability, you can switch employers and start working for the new employer in the H-2B context. I don't know exactly what visa you have. Certain visas have different grace periods and different rules on whether you have to wait until it's approved or not before you can transfer. So that's the answer for H-2B context anyway.
Thank you. Next question is, I found a better job with another company. Can I switch legally while still in the US, or do I need to go back home first?
Most visa types will allow you to change employer or change status. So even if you say you're on H-1B or you're on L-1 and you found a different job with a different company and you want to switch to H-1B and they've sponsored you for that, you can certainly do that, and do a change of status. But you want to make sure the employer you're going to actually qualifies for a visa type. Like, there needs to be a proper visa type that job falls into, because that happens sometimes. So especially in H-2B, where I have this job and I want to switch to, I work for this restaurant, but I want to switch to this restaurant down the road. But the restaurant down the road maybe doesn't qualify for H-2B and doesn't have a labor certification. So while they want to offer you a job, that doesn't mean they actually have the means or eligibility, meet the eligibility requirements for sponsoring you. So just be careful about that.
Thank you. Next question is, if my employer ends my contract early, can I legally switch to another H2 job, or do I have to leave right away?
You get to that 30-day grace period to find a new employer from the day that you're terminated. You can switch employers via that change of status or change of employer we talked about, or you can return to your home country and process via the consulate if that's an option. It just depends on the circumstance on whether that is going to be an option, on what the prospective employer would like to switch to. Because again, this happens quite often where someone met someone locally and you're an H-2B worker and the employer up the street says, I really like this person, I would like to hire them. And then I talk to the new employer and they don't do H-2B presently, and it's not the kind of job where you can just change at any point during the year. The H-2B has a very strict filing timeline. So if the employer hasn't already started that process or isn't already actively sponsoring other H-2B workers where they can just add you to their existing petition, or certification, use the existing certification, it's not something where you can spontaneously just switch, to a new employer unless that new employer is ready to do that and qualified.
Thank you. Next question is, my employer constantly makes me do duties that are not within my job description. Can I leave the job and apply somewhere else without losing my visa?
You can definitely look for another job. And also we talked about the different reporting options for nonprofits that help, targeted workers that are foreign workers that need help. Also, you can, report them to Department of Labor, depending on, the visa type, and just let them know that you're working beyond the approved authorized duties that you've been assigned. Because again, in most visa categories, the duties and job will really align very closely with what the proper pay rate is. So, if something like this is happening, there are avenues to look for whistleblowing. But yes, if you can find another employer, you can look for other employment. I don't recommend doing that, and just quitting and looking for something else. Usually that happens if you're terminated, not if you voluntarily quit. So usually you're going to want to line that up while you're still working for the other employer in most cases.
Thank you. Next question is, can I bring my husband or children with me on my H2 visa, or will I have to go home or go alone?
So H2 categories A and B are eligible to bring family members. So that's spouse or children under the age of 21. Usually that's not something the employer is required to cover, especially for H2A, where you're probably staying in employer provided housing. You're going to be responsible for housing your family. You're responsible for paying the visa fees and travel for your family. So from that, from a feasibility standpoint, it is possible, but your employee is going to bear the cost of that. Also, one thing to caution, especially with H-2B, because it's such a short program, and because unfortunately, many of the workers from countries that these workers are from tend to have higher than average overstay rates. That used to be the reason for the country list, is they just viewed there were certain factors that certain countries didn't qualify. They felt for H-2B, but it can make it, if you are sponsoring your whole family, it can make it more difficult for your H-2B visa to be approved in future times, because the way the government will look at it is there's something they analyze called your ties to your home country. So if you're bringing your entire family and you have no property in Mexico, no job to go to in Mexico, or that, just saying Mexico is the most common that I've dealt with this issue, your home country, pick your country. If your whole family is here, it's more likely that the officer will use their broad discretion to say, you have insufficient ties to your home country, so we're going to deny you this temporary visa because we feel like you're too high of a risk of overstaying the visa. So feasibly, yes, it's possible, but it can cause some additional risks to your underlying visa in the future.
Definitely. Thank you for that. Next question is, and this is the last question, and you did answer this, but just to reiterate, how can people apply to H2 visas?
So I get this question a lot because it's kind of misunderstood, especially with as much as I post on LinkedIn and on social media. Um, most attorneys like myself, we handle the employer side of it. So we handle the steps with Department of Labor and USCIS where we're getting the employer certified so that they are then able to recruit and sponsor workers. Um, I don't know of many attorneys, if any, that provide recruitment services. So I'm not the right person, and attorneys aren't the right person to say, I would like an H-2B visa job. Can you refer me to a job? That's not something an attorney is really going to be able to help you with. You're going to need to look at recruiters. And I know that can be difficult to find a reputable recruiter. DOL does post a recruiter list. If you look on DOL's website, you can see the H-2B recruiter list. Um, you know, I can't personally vouch for any one or the other because I can't really make endorsements like that. But, that's one place is, the best way is to find a good recruiter and get into their pipeline. If you know other workers that are on H-2B, that actually is probably the strongest referral source, because if their employer or a neighboring employer needs a new worker, they trust firsthand experience from their current employees to say, hey, I know this guy, they would be a good fit. And I know this doesn't apply for many of you watching, maybe you don't know anybody that has H-2B. So you're really going to be heavily reliant on that recruitment. But just a reminder, if you are trying to connect with a recruiter, make sure they're not charging fees, because that's not a good recruiter. It's going to get both you and the employer in trouble. So that's not going to be the best way to do it. It's also possible for you to apply directly to the jobs on seasonaljobs.gov. That being said, those jobs are postings are intended to provide avenues for U.S. applicants to apply to these jobs. So often, if you're applying as a foreign national, it's going to be, your application is going to be overlooked, because that purpose of that recruitment is to hire U.S. workers, not foreign nationals. That comes. So that's being said, some employers do use those applications as well. So I just wouldn't say, don't get discouraged necessarily. There are multiple avenues you can try.
Definitely. Thank you for that. I think those are all of our questions. That was an incredible session. Thank you so much for joining us, and a huge thank you to our special guest, Attorney Kitchener, for your practical and strategic insights. We hope this webinar helped answer your questions on H-2A visas. Remember, at immigrationquestion.com, you can ask your immigration questions for free and get connected with a licensed attorney in good standing who can help you better understand your options. You may also qualify for a free initial confidential consultation. Just visit our site to learn more. Don't forget, you can rewatch this session or listen to previous episodes on Spotify. Just search Borderless Talk by immigrationquestion.com. Join us again on Friday for another enlightening edition regarding another burning immigration topic. Trust us, you won't want to miss it. Once again, thank you, Attorney Kirchner, and we look forward to having you back again. Thank you so much.
Thank you. Yeah, thank you for having me.